I spent 30 years applying the law. Now I am going to tell you what the law will not do for you. My name is Thomas Warren. I sat on a family and probate court bench in the United States for 3 decades. 2,041 cases in 30 years. Wills, estates, guardianships, inheritance disputes. Cases that destroyed families over amounts of money that some people would call modest. Cases that tore apart people who had loved each other for decades, who had built lives together, who had shared everything, and then, when one of them died or became incapacitated, discovered that the legal machinery they never thought about had been grinding silently beneath them the whole time. I retired at 62, not because the law required it. The law did not require it. I retired because I reached a point where I realized I had more power speaking plainly to the public than staying silent behind a bench. I had spent 30 years watching the same preventable mistakes destroy families over and over again. The same documents, the same misunderstandings, the same trust placed in the wrong person at the wrong time, the same shock on people's faces when they sat in front of me and learned what the law actually says versus what they thought it said. So here I am, no robe, no bench, and no obligation to be careful with my words. I am going to tell you about Frank and Dorothy Caldwell. They were both in their late 70s when their case came to my courtroom. Frank was 78. Dorothy was 74. They had been married for 52 years. 52 years is a number that most people hear and then move past too quickly. I want you to hold it for a moment. 52 years of waking up in the same house. 52 years of knowing the way the other person takes their coffee. 52 years of arguments and reconciliations and seasons passing, and children growing up and grandchildren visiting, and all the accumulated texture of a life built together. Frank was a retired machinist. He had worked at the same manufacturing plant outside Columbus, Ohio for 31 years. He was the kind of man who fixed things himself, who took pride in keeping a house in good condition, who never called a plumber when he could learn to do it himself. His hands showed what his life had been. Dorothy was a retired school secretary. 30 years in the same elementary school in a suburb of Columbus. She knew every child's name, every parent's face, every teacher's coffee order. She was organized, reliable, and precise. She balanced the family checkbook with the same care she had given to school records for 3 decades. They had 3 children. Gary was the oldest, 51 years old. Then there was a daughter in Cincinnati and a son who had moved to Pittsburgh years earlier. Their home in Columbus was everything to them. Not metaphorically, literally. It was their primary financial asset, their retirement security, the proof of everything they had worked for. They had paid off the mortgage completely in 1998. That final payoff had taken 24 years. 24 years of prioritizing the mortgage over vacations, over new cars, over the things that other people their age were buying and enjoying. When they made that final payment, Frank told me later, Dorothy cried. Not from relief, from pride. The house was valued at approximately $215,000. By the standards of Columbus, Ohio, that is a modest property in a working-class neighborhood. A 3-bedroom house with a yard and a garage and a kitchen that Dorothy had remodeled herself in 2007 and was proud of. It was not a mansion, but it was theirs, fully. No mortgage, no lien, no claim against it from any creditor anywhere. The word paid off, when Frank said it, carried the weight of everything it had cost to get there. Now let me tell you about Gary. Gary was 51 years old in the spring of 2022. He was Frank and Dorothy's oldest child, and he had always been the restless one. He moved through phases. In his 20s, it was construction work. In his 30s, sales. In his 40s, a series of small business ventures that he described with great enthusiasm at their beginning and abandoned with little ceremony at their end. There was a landscaping company that lasted 18 months, a pressure washing business that lasted less than a year, a brief investment in a self-storage unit that he co-owned with a friend for 2 years before disagreements ended that partnership. There had also been a period when Gary borrowed money from Frank to invest in what he described as a real estate opportunity. That money was never fully repaid. Frank did not ask about it again. Gary was not a bad person in the way that word is usually used. He was not cruel. He was not cold. He was someone who believed, persistently and against the available evidence, that the next thing would be the thing that worked. He had confidence without the discipline to sustain it. He had plans without the patience to execute them. He had the particular optimism of someone who had never fully reckoned with what had gone wrong before. In the spring of 2022, Gary had decided the next thing was roofing. He had done roofing work before, years earlier, and he believed he understood the industry. He had contacts, he said. He had ideas. What he needed was capital. And capital, he had concluded, was the only thing standing between him and success this time. Gary did not go to a bank. Banks ask questions. Banks want credit histories and business plans and collateral and detailed projections. Banks would have asked Gary to explain the landscaping company and the pressure washing business and the real estate investment that had ended in a disagreement. Gary did not want to answer those questions. Gary went to his parents' house in Columbus and sat down in their living room. What Gary said to his parents that afternoon was measured and reasonable. He had thought through how to say it. He told them he had been thinking about their situation. He said that when they eventually passed away, their estate would go into probate court. Probate, he explained, was expensive, slow, and complicated. It costs money. It takes time. The estate gets tied up in legal proceedings for months, sometimes longer than a year. Families have to hire attorneys. The court collects fees. Assets get frozen during the process. It creates stress and conflict and delays at exactly the moment when families are already grieving and vulnerable. He had a solution. If they transferred the deed to the house into his name now, while they were both alive and healthy, then when the time came, there would be no probate. The house would already be in his name. It would transfer automatically. No court, no fees, no delay, no conflict. Clean and simple. And nothing would change in their daily lives, he emphasized. They would stay in the house. They would continue paying the property taxes and the homeowner's insurance. They would manage everything exactly the same way they always had. It would just be a change on paper. A legal technicality, he called it. Frank and Dorothy listened to their son. He spoke with the confidence of someone who had thought this through. The logic, as they heard it, seemed to make sense. They were not lawyers. They did not know what a quitclaim deed was, precisely, or what the full legal consequences of a title transfer entailed. They knew that probate sounded like something to avoid. They knew that their son was sitting in their living room, apparently trying to help them. Dorothy asked whether they should talk to a lawyer first. Gary said it was not necessary. This was a standard thing that families did all the time. His neighbor had done the same thing with his parents, and everything worked out fine. Lawyers just charge money to tell you things that are common knowledge. He had already researched it. There was nothing to worry about. Dorothy turned to Frank. Frank considered for a moment. Then he said, "All right." I have thought about that moment many times since I read the file. 2 words. All right. The transfer of a lifetime of disciplined payment and sacrifice in 2 words. I do not say that to condemn Frank. I say it because I want you to understand how easily it happens, how ordinary the conversation sounds, how reasonable the person sitting across from you seems, how much you want to believe that your child is trying to help you. Frank and Dorothy did not make a reckless decision. They made a trusting one. There is a difference. The law does not care about that difference, but I do. In March of 2022, Frank and Dorothy Caldwell drove to the county recorder's office in Columbus, Ohio. Frank signed the quitclaim deed. Dorothy signed the quitclaim deed. The property was transferred into Gary Caldwell's name. The transaction cost them a small filing fee. They drove home. They had no idea what they had just done. The next 8 months were entirely ordinary. Frank maintained the yard through spring and summer. Dorothy cooked. Their grandchildren came to visit in July and used the backyard the way children use a grandparent's backyard. Frank paid the property taxes in September, as he had done every September for 24 years. He paid the homeowner's insurance premium. He repaired a leaking pipe in the upstairs bathroom. He and Dorothy watched their evening programs. They lived in their house the way they had always lived in it. During those same 8 months, Gary was moving. He had presented himself to a mortgage lender as the owner of a property in Columbus, Ohio. He was the owner, legally. The deed bore his name. He applied for a home equity line of credit against the property. for $180,000. The lender reviewed the title, Gary Caldwell. No existing liens, no encumbrances. The property was clear. The lender approved the credit line. Gary used that money to start a roofing contracting business. He leased equipment. He hired 2 employees. He bought a truck. He obtained a business license. He had business cards printed with the company name and his phone number. He opened a commercial bank account. He took on his first jobs. He was optimistic. Gary was always optimistic at the beginning. The business failed. The reasons are familiar to anyone who has watched a small construction company fail. Undercapitalization from the start. Poor cash flow management. A large commercial contract that went over budget and consumed most of the available margin. A key employee who quit without notice. Smaller jobs that came in slowly when the season changed. Gary began missing the monthly payments on the HELOC in the fall of 2022. 1 month, then 2 months, then 3. The lender sent notices to the business address Gary had listed. The notices did not go to the Columbus house where his parents were living. Frank and Dorothy received nothing. In February of 2023, a letter arrived at the Columbus house, addressed to the owner of record. Frank opened it. He stood in the kitchen and read it. It was a notice of foreclosure. The lender was initiating formal proceedings to seize the property due to non-payment of the home equity line of credit. Frank read the document twice. He set it on the kitchen counter. He sat down at the table and was quiet for a long time. Dorothy came into the kitchen and saw his face and asked what was wrong. He handed her the letter. They did not know what a HELOC was. They did not know that Gary had borrowed against the house. They had not known the house could be borrowed against. They had not known that by transferring the deed, they had given Gary the legal authority to do exactly what he had done. They had thought it was a change on paper. Frank called his daughter in Cincinnati. She was a paralegal and had been for 12 years. She was the one who had warned them before they went to the recorder's office. She had said, "Dad, please talk to a lawyer before you do this." He had not listened. Now he was calling to tell her what had happened, and she chose at that moment not to say the words that were available to her. There was no version of "I told you so" that would help anyone. She told her father what options existed. She could file an emergency petition to challenge the foreclosure. She could argue that the lender had a duty to disclose the HELOC to the actual residents of the property before extending credit. She could argue that Gary had misrepresented the purpose of the deed transfer to his parents in order to obtain a property he intended to encumber for personal financial gain. She could make several arguments. She also told him what she could not promise. The deed transfer was voluntary and properly executed. There was no forgery. There was no evidence of physical coercion. Gary could argue, and he did argue, that he had been explaining a legitimate estate planning strategy to his parents, and that they had agreed of their own free will. Proving that the conversation constituted fraud, rather than a misguided but voluntary transaction, would require a standard of evidence that was very difficult to meet. Frank and Dorothy retained a local attorney and filed the petition. The case came to my courtroom. I read every document in that file: the quitclaim deed, the HELOC application and approval, the payment history showing 6 consecutive missed payments, the foreclosure notice, the petition filed by the attorney, the affidavits from Frank and Dorothy explaining what Gary had told them, the response from Gary's attorney asserting that the transfer was voluntary and that the HELOC was a lawful transaction by the title holder. I looked for a legal basis to stop the foreclosure. I looked for evidence of fraud sufficient to void the deed transfer. I reviewed the misrepresentation claim. I reviewed the argument that the lender should have investigated whether elderly residents were living on the property before extending credit. I could not find a basis in the law to stop what was happening. The deed transfer was valid. Frank and Dorothy had signed it. They were mentally competent when they signed it. The recorder's office had processed it correctly. There was no procedural defect. The HELOC was valid because the lender had a right to extend credit to the named owner of an unencumbered property. They had no legal obligation to investigate whether the owner's parents lived there. They had done what lenders do. The foreclosure was valid because the HELOC was valid and the payments had not been made for 6 months. Gary had the legal authority to do everything he had done. The law had no mechanism to punish him for the manner in which he had obtained that authority, because what he had done was tell his parents something that was partially true and leave out the part that would have mattered. I delivered my ruling. The foreclosure would proceed. The Caldwells would receive a vacate notice. They had 30 days to leave the property. I have sat on that bench and delivered hundreds of rulings. Rulings that ended marriages, that awarded custody, that froze estates and removed guardians, and settled disputes that had been festering for decades. You learn, over 30 years, to hold the authority of a ruling with care and not with pride. The ruling does not belong to you. It belongs to the law. You are the instrument through which it is delivered. You are not permitted to flinch from it. But there are rulings that stay with you. This is one of them. I remember Frank Caldwell sitting in the gallery. He was a compact man with the kind of stillness that physical work gives you over a long life. He understood, before I finished the sentence, what the ruling was going to be. He had been in the courtroom long enough to read it in my posture, and when I delivered it, he did not argue. He did not react with anger. He accepted it with a dignity that I recognized as the particular dignity of a man who had worked honestly his entire life, and knew that he had no one to appeal to, and no recourse left. He folded his hands in his lap and looked at the floor. 2 weeks after the vacate order, Dorothy had a stroke. The hospital described it as mild. There is no such thing as a mild stroke when you are 74 years old and have spent the previous 3 months learning that your home, the home you paid for over 24 years, is being seized because of a debt your son accumulated without your knowledge. Dorothy was hospitalized immediately and transferred to a rehabilitation facility, where she spent 6 weeks. Frank moved into his daughter's basement in Cincinnati. He sold most of the furniture before he left because it would not fit in a basement. He kept the photographs. He kept Dorothy's recipe cards. He kept his tools. He left behind the kitchen she had remodeled in 2007. The house sold at foreclosure auction for $222,000. The lender recovered what it was owed. After fees and legal costs, the surplus was modest. Gary was entitled to it as the owner of record. I do not know what he did with it. I know that Gary did not face criminal charges. I know that what he did was legal. Now I am going to tell you 3 things. Write these down. The first thing is this. A quitclaim deed is permanent. When you sign a quitclaim deed and transfer your property to another person, the property is no longer yours. There is no cooling off period. There is no return. If the relationship changes, if the person loses their judgment, if their financial situation collapses, if they simply change their mind about treating you fairly, you have no legal remedy because you no longer own the property. You can go to court. You can hire an attorney. You can spend money you do not have on litigation that will likely fail. But the deed is recorded, and the law will enforce what the deed says. The second thing is this. Every creditor of the person who owns your property has a potential claim against it. When Gary became the legal owner of that house, every future financial obligation Gary incurred became a potential claim against that house. His business debt, a lawsuit from a contractor, a divorce, a tax lien, a medical bill. You transferred the asset along with the authority. You cannot control what the title holder does with property that belongs to them. The house you paid off in full, the house with no mortgage, the house that represented decades of disciplined financial decisions, became collateral for someone else's judgment and choices the moment you signed the deed. The third thing is this. Probate is not what your child told you it was. A straightforward probate for a modest estate in most American states takes 4 to 6 months and costs between 1% and 2% of the estate value. That is real money. That is real time. But compare it to what Frank and Dorothy paid. They did not pay 1 or 2% and wait 6 months. They paid their home. Dorothy paid with her health, and Frank paid with the last years of a retirement he had earned over 31 years of factory work. The cost of avoiding probate the wrong way was vastly greater than the cost of doing it correctly. Let me tell you what would have protected them. A revocable living trust costs between $1,500 and $3,000 to establish with a qualified estate attorney. It accomplishes everything a deed transfer is supposed to accomplish, and more. The property is placed in the trust. The trust transfers to the named beneficiary upon death without any probate proceeding. No court, no delay, no attorney fees for the transfer itself. But here is what is different. While you are alive, you remain in full control. You are the trustee. You manage the property. You can change the beneficiary at any time. You can remove someone from the trust if the relationship changes. You can sell the property or modify the trust or revoke it entirely if you change your mind. If Gary had been a beneficiary of a revocable living trust instead of the title holder through a quitclaim deed, he could not have taken out a HELOC against that property. He could not have borrowed against it. He could not have encumbered it in any way. Frank and Dorothy would have continued to live there as the trustees of their own property until they died. At that point, the trust would have transferred the property to Gary automatically and without any court involvement, which was exactly what Gary claimed he wanted for them. The same result. Zero risk to Frank and Dorothy. Zero. There is also a simpler instrument called a transfer on death deed, which is available in Ohio and many other states. You record the deed with the county, naming your beneficiary. The property transfers automatically upon your death to that person, bypassing probate entirely. But during your lifetime, you remain the owner. The named beneficiary has no rights to the property while you are alive. They cannot borrow against it. They cannot sell it. They cannot mortgage it. It is yours until the moment you die. This document can be drafted by an estate attorney in an hour and recorded for a small fee. Frank and Dorothy could have accomplished everything Gary told them they needed to accomplish for roughly $300 in one afternoon. They needed one conversation with one attorney. One conversation. That is all that stood between them and losing their home. I want to say something about Gary before I close. Gary did not go to prison. Gary did not face civil liability because the deed transfer was voluntary, and he had the legal authority, once the deed was in his name, to do what he did with his own property. His roofing business failed, and he had to live with that failure. But there were no legal consequences for what he had done to his parents because legally, he had done nothing wrong. He moved on. He remarried. He started another business. I have no information that he experienced any legal difficulty as a result of what happened to Frank and Dorothy. He was right, in one narrow and terrible sense. Everything he did was legal. Frank is in his 80s now. Dorothy recovered from the stroke, but not fully. She uses a cane. She tires more easily than she did. They live in their daughter's home in Cincinnati. Frank has a room in the basement. Dorothy has a room upstairs. They see their grandchildren. They do not see Gary often. Frank spent 31 years in a factory and 24 years paying off a mortgage. He did everything by the book. He trusted his son. The law could not help him. The law is not designed to protect you from the consequences of documents you sign voluntarily. The law is designed to enforce those documents. That is what the law does. That is what it will do for you in my courtroom, or in any courtroom in this country, if you sign a quitclaim deed and then come looking for justice. I am not in the courtroom anymore. I am here, and I am telling you this before you sign anything. Share this with someone who is thinking about transferring their home to a child. Share it with someone whose parent is being asked to do this. Share it with someone who believes that avoiding probate is worth giving up ownership. Because the people who sat in my courtroom did not believe it could happen to them either. They believed they knew the person they were trusting. They were right about that, and it still happened. Subscribe to this channel. Leave a comment below and tell me what situation you are facing, or what you have seen in your family, or what question you cannot find a clear answer to. I read every comment. If there is something I can clarify about what the law will and will not do, I will do it in the next video. I spent 30 years applying the law. Now I am telling you what the law will not do for you. Thank you for listening.